The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here this afternoon for the submission of 4 separate cases. The case of Iowa Supreme Court Attorney Disciplinary Board versus Jeffrey Michael Jansen is hereby submitted without oral argument. And the case of State versus Michael Richard Patton is also submitted without oral argument. We'll now begin our first oral argument today. State of Iowa versus John Haynes. It looks like the parties are ready. Mr. Bjornstad, you can go first.
The court. Counsel. Hello, thank you for having me here. My name is Jack Bjornstad, and I'm from Spirit Lake. I represent John Eddie Haynes III. Our Constitution provides protection from being imprisoned or jailed if the facts don't add up to the elements of the offense. It's our courts that have a non-delegable duty. Defense counsel does too, as well as prosecutors, but we all have a duty, and we can't delegate it to others to afford that protection and make sure that nobody goes and sits in prison if the facts don't add up to the elements. The legislature, though, has been very busy lately. They have passed a number of laws that have gotten in the way of the vehicle that courts and lawyers have used to ensure that nobody's sitting in prison when there's no factual basis. And that's what this case is about, is the conflict there between the steps the legislature has taken recently and John Eddie Haynes III, who's sitting in prison based on facts that don't add up to the elements of his offense. The old way would be to go ahead and say that his attorney, his defense counsel, had been ineffective because he allowed the plea to go forward. But the legislature has said there will be no more direct appeals concerning ineffective assistance of counsel. So that's what we're proposing, is a new vehicle to help the justice system get its job done.
Mr. Bjornstad, but the way I'm looking at it is, you're right. They've taken away one of the options, and you're asking for a new option. And instead of ineffective assistance of counsel, am I correct that you are saying the court has the burden to arrest your judgment?
Your Honor, I think.
My concern is, I think you're right. There is a duty if, that's a big word, if. So the motion to arrest your judgment, there is a job of the court to kick in, but it talks about if this is not done, then the court does that. Aren't you kind of, in a sense, making an ineffective assistance of a judge?
And that's why this exception that we're asking for is structured very closely on the old method of saying, well, the attorney was ineffective. As defense attorneys, and there are more here, but we've been falling on that sword for 50 plus years, and I don't think anybody minded.
An end run around the statute, you say it's pretty much the same thing, but you're just pointing the finger at a different player?
Something has to be done. We've got to meet the obligation that the Constitution imposes.
Would a petition for writ of certiorari work in this instance, with the judge doing something unlawful by accepting this plea without a factual basis?
Potentially. That potentially would be an answer. But so would this. A lot of times with a pro se or with a defendant in prison, filing a notice of appeal is about all they know how to get done. That might require certain steps to be taken by the lawyer who made the mistake in the first place, and we're back in the situation where maybe a lawyer isn't expected to bring that sort of in the old manner of speaking, an ineffective claim against himself.
Asking us to, in effect, rewrite a rule of criminal procedure that says if you don't move to arrest the judgment, you can't complain about a defect in the plea on appeal, at least on a direct appeal. What do we do with that?
I think that there's no rule or law, for that matter, that can take precedence over our constitutional duty to make sure that nobody sits.
You've said that a few times now, that there's a constitutional duty to ensure there's a factual basis. In the guilty plea situation where the defendant admits to the underlying facts, what's the authority that says that that's that's a constitutional violation? The Constitution says that the guilty plea has to be voluntary and knowing, but at least there are federal cases that say that the Rule 11 equivalent that requires factual basis, that's what requires the factual basis to be found. The Constitution just requires that the guilty plea be knowing and voluntary.
I would question how knowing and voluntary a guilty plea would be in these circumstances, for instance, or in other cases with a lack of factual basis.
Jurisdictions that allow no contest pleas, where there's no factual basis established.
Well, that may be a very different animal, and I don't think that's what we're dealing with here necessarily. It may be different on a...
That have looked at this have, to the best of my knowledge, all concluded that factual basis is not a due process requirement, that the due process requirement is knowing and intelligent guilty plea. And maybe we've confused rule-based violations with constitutional violations. Do you have authority that says you have to have a factual basis or else the plea is deficient for the purposes of due process?
In my opinion, Cisco would be the leading case there that lays it out pretty clearly that this court does have a duty, this court, the district court, have a duty to ensure a factual basis exists for a plea. I understand the distinction. I'm not sure for John Eddie Haynes III it matters much. If he's sitting in prison and he didn't aid and abet himself with possession of a firearm, I don't know that it makes much difference to him. And we're still left then with the problem of, well, what is the vehicle then that will get us where we need to go?
Why is post-conviction relief an inadequate vehicle? If I understand there's been a long history of using ineffective assistance as an error preservation device on direct appeal. This relevant statute's amended. Now all practitioners know, go to post-conviction relief court and you can get relief. Why is that not an adequate substitute in this case?
This February, I traveled with my family by car to Florida. 3 kids, 13, 10, and 7. And it was, just horrible. We got there, though, and it was my job to get them there safe. I couldn't have said, okay, kids, hop on your big wheels, we're going to Florida. It's too slow. And post-conviction actions are just historically very slow. People would...
That's not inherent in the post-conviction relief process. A post-conviction counsel can expedite and push a case as fast or as slow as he or she wants to, and maybe under this new regime, there's going to have to be a change in practice in the way we think about post-conviction relief proceedings.
All I can
Move the case along.
All I can speak to is my practice, in my experience, generally whether it's a civil action of any kind, but post-conviction also, calling up court administration in my district to get a trial date, you're going to be out a long time. And if anybody would like to go expedite it as far as a motion for summary judgment or those options that might speed it up, you wait an awfully long time for a ruling from a court. The other thing that I haven't seen brought up is, it's not like you get an appeal bail. There's no option for that with a post-conviction. You're just going to sit. And as long as the court system takes, it takes. Then, is there a right to an appeal from the post-conviction? And what happens with the defendant? Does he continue to sit in prison while the appeal works its way through? I agree. You can get there. You can get to Florida on a bike or a big wheel. It just takes a long time. And when a defendant comes before any court, this court, and says, there's a problem. Well, we just need to find a way to fix it.
In Mitchell and in Schminke, we've long said that it's per se ineffective assistance when the situation arises. And so are you familiar with our recent Crawford case that dealt with sufficiency of the evidence following a trial?
Yeah, I'd very much appreciate it.
That's all right. But it's kind of the analog to this situation, except that it wasn't a guilty plea, it was a trial. And so there we said you don't need to bring a directed verdict motion. Right, so how does Crawford play into this case at all?
I don't know that it really does. I think it would support what we're asking for. I think that the focus in that case is much more on the consequences for the defendant rather than rigid adherence to a rule or to a prior practice. So I would say it supports what we're asking. Just to keep our eye on the ball and look out for people's constitutional rights.
A motion and arrested judgment, well, there's several. One, that the district court could correct an error if there was an error here and avoid it all this time. The other would be that the state can adjust. If there's a gap in the record they're able to fill, that could happen then. In this case, if it had been raised below, wouldn't the prosecutor have said, fine, we'll either withdraw the plea agreement or you plead to the felon in possession of the weapon. They're both Class Ds, and life goes on, and the system would have worked as intended.
Yeah, and I've been a prosecutor. I've been a defense lawyer. I think everybody I don't think there are a lot of people out there trying to sneak one past the goalie, but every once in a while it happens. This is a case where it happened. There is a difference between different, for instance, if there's 2 counts, like in this case, there's oftentimes different amounts that the parole board will hold you in prison based on different offenses. And so you can get out a lot earlier, but so there would be, I'd say, reasons that an exception would be needed. The other thing is just human nature. For the same reasons that ineffective assistance of counsel was, nobody expected a lawyer to bring that against himself. Human nature says a district court judge may be a little more reluctant, or a prosecutor to step up and say, we've messed up. Let's undo this.
Difference in the likelihood of an earlier, well, in this case, it was a suspended sentence anyway, so he didn't go to prison, right?
I don't believe so, but I'm
Wrong, but is there a difference between criminal gang participation and a felon in possession of a weapon for likely release on parole?
I don't know. They've hidden some of the statistics there a little recently, so I've tried to check but wasn't able to find anything.
This lawyer made a strategic choice to prefer one offense over the other, even if there was some legal issue over whether it applied. And in this case, the judge did what the defense lawyer was asking.
That may be. We don't know on this record, but
A guilty plea and a trial like Crawford, where he's contesting his guilt all along, and the state is put to its proof. And in Crawford, although ultimately we said there was sufficient evidence, but you get to do that on a direct appeal now.
I think that I'm old enough to remember the Cowell lamps cases. The public has to have confidence in the system that we have, and allowing those guilty pleas to just sneak by when there's no factual basis is something that this court has condemned in the past and said we just no matter how good an outcome it might be or whether it was strategic for the client, we just can't let that go. So
The ineffective assistance of a judge. Where does that slippery slope stop? Should I then, as I'm the judge watching the trial unfold in front of me, should I say, excuse me, defense counsel, this would be a good point to object right here? It could be a critical moment, or if I were you right now, I would move for a directed verdict. I mean, where do you draw that line? Aren't they you're asking a judge, aren't you, to do the job of defense counsel?
I think that's what Cisco calls for is,
The judge takes it upon himself or herself to say, you know what, State, are you satisfied with the recitation of facts? I mean, there's a may in there. There's a permissive quality. The court can do it. But you're saying to put the burden on the judge, that if the lawyer doesn't do it, the judge shall, and if the judge doesn't, it's an automatic go back?
for years, that's exactly what happened to defense counsel, was that, and if I may finish. But that responsibility landed solely and squarely on defense counsel. It's not a pleasant feeling to know one got by, but like I said, I think at the end of the day, I don't think there are judges out there trying to, sneak them through, or attorneys out there, very many of them, trying to sneak things through like that. It's just when mistakes happen to be made. Thank you.
Reinkoester, am I pronouncing it correctly? Oh, we guessed. We were deliberating on how to pronounce it. Thank you.
May it please the court, counsel. In preparation for this argument, I sort of went back and did a history lesson on the origins of motions and arrests of judgment. And it appears that the first time this court required that was in a case called State v. Reeves, which was decided in 1977. And not long after that, the first draft of the criminal rules that came out in 1978 came out before Reeves. And in that, it did not have a requirement for a motion and arrest of judgment. But in 1979, the rules were amended to add what we now know as the motion and arrest of judgment. The requirements have been the same ever since 1979. And a few years later, this court in Worley recognized that that was a bar to attacking guilty pleas on direct appeal. But in that same case is the first time this court recognized that if the court failed to give an adequate advisory of someone's motion and arrest of judgment, that would be an exception to the rule that barred the attacks on guilty pleas. And in that case, the court said that those two rules together, the 2.8 colloquy and then the rule that requires the judge to inform the defendant of the right to file a motion and arrest of judgment, work together for the admirable purpose of permitting a trial court to correct its errors prior to appeal and therefore reduce the amount of appeals necessary for guilty pleas. And that's been the rule ever since. And even as recently as Weitzel, where you can see the court's very strong language in expecting district courts to comply with the 2.82 colloquy, that they still say, or you say, that direct appeals, reversals of guilty pleas on direct appeals will be rare because of that requirement, because you have to file a motion and arrest of judgment first, or have the failure for the...
Let me push back on you to quote Justice Apple. Our cases say that, but we've used ineffective assistance of counsel to circumvent all of those holdings and all of the rules. And we've done that probably close to the time we required motions and arrest of judgment. And we've said the failure to file the motion is per se ineffective assistance when there's no factual basis. So I understand the doctrine says one thing, but there's other doctrine that effectively creates a per se excuse that allows direct appeal or review of factual basis on direct appeal in all circumstances. And that's been the law for a long time. So all that being said, we have always reviewed these on direct appeal. So why shouldn't we continue to do that? Why isn't this a due process problem consistent with our prior case law on the subject?
The legislature has prescribed the framework for which to challenge these. Not only
Due process problem.
no constitutional due process right to a direct appeal from a guilty plea. I mean, this court has recognized in Tucker and Treptow and those cases that the legislature was well within their rights to determine the framework for these.
Framework is, are you talking about the good cause, or are you talking about 814.7 and not allowing ineffective assistance claims to be heard on direct appeal?
Speaking about all of it, but the framework here is, first of all, you have your motion in arrest of judgment, your first line of defense against, any sort of attack on your guilty plea, you have that. And then if, notwithstanding that, if that doesn't happen, you can go to Chapter 822 and get a remedy for any violation there.
Assume that Mr. Haynes was pro se here. What's his remedy?
I'm not sure that he had one, but
He'd be stuck in jail with, well, I guess he'd be stuck with whatever he was stuck with. I don't know if he was incarcerated or not, but with no remedy?
I mean, I believe that would be the case, and that's because this court has long held that pro se defendants, proceed at their own risk. And part of that is you are not permitted to raise, ineffective.
To that framework. So first, the court or the legislature said there has to be good cause. Prior to that change, if a defendant pleads guilty without there being a factual basis, and his counsel fails to file a motion in arrest, we would have still heard that on direct review, on direct appeal, because that was per se ineffective, both to not make sure there was a factual basis and not to file the motion. So now the legislature says you have to have good cause, and we've said that good cause is a basis on which we could grant relief. And we could grant relief, if you put 814.7 aside, we could grant relief in this situation because assuming that there was not a factual basis, because the ineffective assistance gets you past the requirement for the rule. But then you bring in 814.7 then. So do you have to rely, first, do you have to rely on both 814.6 and 814.7 for your process?
I don't know, is the you in that situation the defendant or the state?
All right, I meant the state. So is the state relying on both 814.6 and 814.7 to say that the defendant cannot get a direct appeal here?
Yes. And so two things I want to address there. First of all, I mean, both you and Justice McDonald said the per se prejudice. I do think that there are cases that say that prejudice is inherent, but there's many cases that also say it's presumed prejudice. So I think in this court has been a little inconsistent about the prejudice.
Well, we said it's per se, and even Mitchell even recognized that there might be situations where maybe it was that the counsel had, maybe it was a statute that was ambiguous, and so there was some professional judgment there. But a little bit like your opposing counsel said, we kind of just made the defense counsel fall on their sword, and we said it's per se. So, and maybe there are other cases that say different, but tell me why Mitchell isn't right.
I don't know why Mitchell. I mean, I'm not saying that it is whether or not it is per se or presumed. I'm saying that this court has been inconsistent in its use of language about which level of prejudice it is, and so there has been confusion. I mean, in Straw it says presumed prejudice, but going back to the first, your question before, you're sort of incorporating the logic from Crawford into this case, and Crawford is just not at all applicable to this case. Not only because we have someone who is pleading guilty, who is admitting to the facts of the case. We don't have an innocence problem. We don't have a sufficiency problem. We simply just have a record problem if there is a lack of factual basis. And second, one of the reasons that, that I read Crawford to say that they are allowing this type of error preservation solely through trials instead of having to file the motion in arrest of judgment is because a remedy can be granted on the record that comes before this court. That cannot happen in a factual basis claim. You cannot provide a remedy here.
I'm intrigued by Justice McDermott's hypothetical. You know, what do you do about the pro se defendant? Does that mean they're out of luck because they don't have an ineffective assistance of counsel claim? That problem existed under the old framework, right? That prior to the 2019 legislation, they wouldn't have had a way to challenge lack of factual basis, right? That's correct. So it's not like the 2019 legislation created some problem that didn't exist before.
And it just sort of reestablished the rules as they always were and as they always had existed in this court's cases. I mean, a lot of the framework for the 589 bills and these statutes that we're talking about came from this court's cases and this court's, constant and always consistent position that certain claims were preferred to hear on PCR, even though we heard them on direct appeal sometimes. And so it simply used that framework to create a statutory structure and moved that all to PCR. And that's why I actually think a factual basis claim is better on PCR, because
Follow up with that, because I guess my understanding of factual basis is we look at what the record was before the district court. So what else is there to develop on PCR?
remedy is not, this court's remedy isn't then to just dismiss this case or the counts against the defendant. It is to remand it to the district court for the state to present additional evidence or to have the defendant, make a more sufficient confession or, to the elements of the crime.
Remedy that we can provide.
Providing is to send it back to the district court to do what the district court was supposed to do in the first place. The remedy for a sufficiency claim under Crawford is there is nothing else in the record. On a PCR, the state cannot introduce any evidence that would make a sufficiency claim more or less, great, better or worse. But that's not true for a factual basis. The state can come back and is supposed to come back with the evidence to show that the factual basis. That can only be done at the district court because this is a deficiency of the record.
Doesn't that depend on the type of lacking factual basis? I mean, and Mitchell involved the one where he was charged under the wrong statute. And so we actually did send it back for dismissal. And so is this that situation? So if we reach the merits, is this that situation on factual basis where there is not evidence to support the gang activity and he really should have been charged maybe as under the felon in possession?
And defendant doesn't even make that argument. In his brief, he even says this is just a mistake, that they all forgot to say what crime it was. And in fact, going back and reading the minutes of testimony, and this probably should have been in my brief, I didn't catch it the first time, but his co-defendant, who also fled from the car, was in possession of marijuana at the time. And in fact, they believed that what was happening was that there were drug distribution going on here. So the minutes of testimony do provide, significant information about what crime he was aiding and abetting, even if it's not necessarily sufficient on this record.
This is a plea bargain, right? So if in the old days, if we would send it back, and even if the state couldn't, or the parties couldn't demonstrate a factual basis, the state could reinstate count 2, right?
And the other issue, in terms of the merits of the defendant's argument in this particular case, is that there is no mention in his brief of 814-29 or the requirement of showing that he would not have pled guilty had he not. I'm not going to say the whole phrase because it's a little awkward, but there's no mention in either of his briefs of that requirement, and he has certainly not made a showing that he wouldn't have pled guilty here had there been, had he known of the mistake beforehand. So in terms of the merits of this particular case, I think that forecloses any argument of it even, going back because, the legislature has that requirement now. There's no challenge to it. There's no mention of it, and there's no, attempt to meet that requirement.
We treat this as a petition for cert under Rule 6.108.
Because I believe the rule that requires the motions and arrest of judgment are more broad. It doesn't, say that it just precludes direct appeal. It precludes an attack on the guilty plea. So that would, preclude any attack on the guilty plea regardless of the method of appeal.
2B says that a court shall not accept a plea of guilty that does not have a factual basis. Isn't that illegal activity by the judge that would be subject to a petition for cert?
No, I don't think so. It's a rules-based requirement that the court do it, but the fact that they don't comply with it doesn't mean you get an automatic appeal. I mean, as Justice Christensen was saying, there are lots of errors that happen every single day in courts where the judges are the ones who are supposed to be making those decisions. But
I think this is related to that. So let's go back to this ineffective assistance claim and our case law that says this is a per se ineffective assistance of counsel claim. And I understand maybe some say presumed prejudice, but there's at least a good body of case law that says it is a violation. If those cases are correct, isn't that necessarily a due process violation as well?
I mean, I'm not sure if I know the answer to that. But if it is, then it's in that.
Claim, Sixth Amendment ineffective assistance of counsel claim. By necessity, wouldn't that also be a 14th Amendment due process violation because the Supreme Court's applied the Sixth Amendment through the 14th, right? So it has to be a federal due process violation, right?
I guess. I really don't know the answer. I mean,
For the disposition of this case, if this is a due process violation, how can we say, or why would that not require direct review?
things are, I don't know that it is a due process violation. I think you're correct that I don't know of a case that says a lack of factual basis renders a plea, involuntary and therefore is an unconstitutional plea. But once again, even if it is a due process violation, he has a remedy. Excuse me, Your Honor, may I finish the answer? He has a remedy, and that is through PCR. There is no constitutional right to a direct appeal from this type of case. This court has recognized that over and over. So this just provides a different remedy for him, and I don't see where there's a constitutional violation in that. I mean, I think in order to circumvent the rule requiring the motions and arrest of judgment, you would have to find that there is a constitutional right to appeal from a guilty plea. And I don't think this court has ever recognized that. Thank you.
Mr. Bjornstad.
Uh, 814.29, I'd like to deal with that first. For 814.29 to kick in, we've got to be able to show that he wouldn't have taken this deal or he wouldn't have done it. The whole brief, the whole argument is that he couldn't have. He couldn't have done this. I mean, forget wouldn't. He wouldn't have been able to, he wouldn't have been allowed to by the court or by his lawyer or by the prosecutor. And so to say couldn't or wouldn't, it doesn't matter much in this case if there's not a factual basis. Concerning that factual basis, I've looked at those minutes too, and I've gone back and tried to piece together, well, is there a way they could get there, a different, cobbling something from the minutes together? There's not, and the big reason is you got to look at the language of the plea because that's what controls. And the language of the plea is just pretty clear that he says that his crime was his possession of a gun while being a felon. As far as, the court going off and looking for a different crime that might potentially have been there, that possession doesn't do it. How do you aid and, you don't know what's in my briefcase right now, and just because you're here doesn't mean that you're all aiding and abetting me in possession of whatever's in there. And the same would go for that car. That may not even be a possession case. That certainly isn't on these facts. I think we got to go back to the language of the plea. The firm ground that we have is that it was possession as a felon. Would he go back? Would he go back and get a different plea bargain? Maybe. Maybe at that point everybody realizes, you know what? The count about gang participation isn't going to hold up. We got to come up with a new offer. And maybe that offer is not just go ahead and take the next D felony down the line. You know, maybe they bargain from there. So this has some pretty big consequences.
Weapons charge, that was in the original trial information. There were 3 counts, and then later on, there's simply no mention of it.
No, I don't know, but I can say that from the minutes, it's awfully hard to get to the carrying weapons. There are 3 men in the car and 2 guns, and it's hard to get there, just from the minutes alone. The exception that we're asking for is, it's not going to upset the apple cart too much. You know, as was pointed out, this is exactly what we've been doing for a very long time. So it's a small exception that we're asking for in limited circumstances, but it's just the bare minimum. It's just the bare constitutional minimum that we can get away with. And so
If we were to find good cause in this case, where there's no motion and arrest of judgment, it was because the record doesn't show a factual basis, would that mean we'd also find good cause if there was no motion and arrest of judgment? And let's say the judge hadn't gone through the colloquy properly, had missed some points in the colloquy. Would there be good cause there as well?
And I mean, I can see how that might be. You'd have to have a legally sufficient reason, and a lot of those old, you know, the prior jurisprudence on ineffective assistance of counsel being raised on direct appeal, that might be sort of plug and play with a rule. But for now, it would just be these limited situations where no factual basis.
To see if there's any way that we could say no to a good cause argument if we said yes to you.
Yes, well, I mean, I know the legislature has their ideas, but why? You know, it would probably, it probably does matter on the, you know, does the level reach to a, you know, a constitutional duty of this court to ensure that it happened, or has there been some, you know, substantial compliance? I can appreciate the question, and I can see the can of worms that it potentially opens, but you know, most of that can of worms was created by this court, and they're, you know, they're awful good worms to have in the can. So that they were helpful then, and they'd be helpful today.
2019 legislation was intended to enhance the finality of guilty pleas and wouldn't allowing us defense lawyers to skip the motion and arrest of judgment. And then I realize you weren't the lawyer then, you came in for the appeal, but if we can skip that step and then do a direct appeal of the guilty plea, we've undermined the finality, right?
And we should. I'm sorry. We have and we should. If there's no factual basis, we should undermine that finality, and there ought to be a tool and a vehicle to do it. What the legislature has done is come and try to take that tool away.
Case that says it's not a gang participation to be in a car with several other gang members who are armed.
And I sweated on that last night.
Issue than a factual basis issue.
I think that would really open the door for a wide net. I mean, you could literally go, if you're a prosecutor or an officer, you could go round up half the town and say, well, you're all in a gang, you're all charged, and because you're in a gang, you're aiding and abetting each other being in a gang. It's just too broad and too unwieldy. But I think the real answer is this. You have to go back to the language of the plea, and the language of the plea itself is the only firm ground here that says the crime was possession of a firearm.
Minutes were accurate as to the elements of the defense. So can we look beyond what was typed in on the guilty plea form and look at the minutes, references to marijuana possession by his companion, things like that?
But again, I know sitting in that chair as a defense counsel trying to get that plea through, I'd want to at least establish that if that's the factual basis here, well, how did you aid and abet that guy with possessing his marijuana? You know, possibly, because you got to have possession with then either intent to sell, or just the possession itself, or it's just the fact that you're in a gang and then you've got some marijuana on you, again, it's a pretty wide net.
Of State versus Haynes is hereby submitted. And we'll take a brief pause for the next hearing, oral argument of State versus Stenrup.